Shall we get started? About one more minute to see if Ron joins us.
Did he say he was coming?
I believe so, yes.
Yes.
Okay, it's 7:03. I think we'll get started. If that's okay with everyone. Will the Planning and Zoning Commission meeting of May 19th, 2022, please come to order? We have two public hearings scheduled for this evening, so I want to take a few minutes to review the process for public hearings. During the public hearing, the applicant will be invited to join as a panelist to present the application, explaining to the commission and others present what is being requested. The applicant or staff will share all application materials on the screen as needed. Comments of town agencies will be read for each application if there are any. There will be clarifying questions from the commissioners. Then there will be an opportunity for clarifying questions from attendees. Please raise your hand through the Zoom platform and wait to be called on and unmuted. Next, those who wish to support the application may come forward, and then those who oppose the application may come forward. As this public hearing must be recorded, it is necessary for speakers to identify themselves each time they speak by stating their names and addresses. The applicant will then have an opportunity to address any questions or concerns raised by the public or commissioners. Once the public hearing is closed, the applicant is free to leave or remain for the balance of the regular meeting, during which the commission will try to reach a decision on each application. Each applicant will be notified in writing as to the decision of this commission and has a right to appeal to Superior Court if desired. Decisions of this meeting are available the day after the meeting by calling the Land Use Department at 203-245-5631 after 9 a.m. All actions taken tonight by the commission will be by roll call. All commissioners and staff will identify themselves for the record before speaking. Seated this evening are members Shauna Hay, Elliot Hitchcock, John Mathers, Giselle McDowell, Peter Roos, and myself, Carol Snow. Staff present this evening is Aaron Mannix, Town Planner. The meeting is live streamed on YouTube and will be made available on the town website for viewing. Additionally, I would like to ask that we not use other devices unless needed for the meeting and treat each other respectfully throughout the meeting. The town planner will now read the legal notice. Aaron Mannix.
Notice is hereby given that the Planning and Zoning Commission will hold a public hearing on Thursday, May 19th, 2022 at 7 p.m. via Zoom online webinar. Attendees may join the webinar through either the webinar link or call-in information below. Webinar ID 915-8196-6735, password 452138. The following applications will be heard: 22-09 DVD, 761 Boston Post Road, map 38, lot 96, DVD, Downtown Village District. Owner Davis Realty, applicant Harold L. Blank / Madison Art Cinema, major alteration in the Downtown Village District per section 30 for a digital sign. 22-12, 251 Boston Post Road, map 35, lot 53, R1 District, applicant Fraser Lulage. Excuse me if I mispronounced that. Petition for regulation amendment to Madison zoning regulations, section 4, to allow restaurant use. Further details on how to participate in the webinar are posted on the Town of Madison website, www.madisonct.org. Copies of these applications are available for inspection in the Land Use Office. All written correspondence shall be submitted to the Land Use Department via email landuse@madisonct.org. Dial 203-245-5631 for assistance. Dated at Madison, Connecticut, this 26th day of April, 2022. This ran in The Source on May 5th and on May 12th.
Thank you, Aaron. Could I have a motion then to open the public hearing for 2209 DVD 761 Boston Post Road? And as per the May 13th, 2022 request of the applicant Harold Blank, continue the hearing on June 16th, 2022 so that we may receive video, photographic, and written information for review. Could I have a
Motion to
motion?
open.
Thank you, Peter. Second?
I second.
Shona, thank you. Any further discussion? Let's go ahead and vote. All in favor? Aye, so it's unanimous. Thank you, everyone. Moving right on to the next public hearing. Could I have a motion to open the public hearing 22-12, 251 Boston Post Road?
Motion to open.
I think that was Peter first and a second.
We just ask that the applicant, oh, excuse me, I'm sorry.
Thank
Ask
you.
that the applicant, if you could just please raise your hand as a participant. I was looking for Attorney Jeff Beatty, but I don't see him on, so I'm just curious if somebody is.
Do we have an applicant
Yes.
present to present to us?
I see John Campbell is promote him to a panelist. John, are you representing the property owner, the applicant for this application?
Actually, Jeff Beatty is here with me. Sorry about that.
Wonderful, you're all in one room.
I'm not very savvy technologically.
We weren't sure if you were where we were, so we're here now.
Excellent, thank you.
Could you please identify yourselves then?
Absolutely. Jeffrey Beatty, Sullivan, Griffith and Beatty, 705 Boston Post Road, Guilford, representing the applicant. To my left, your right is Fraser Lulaj, the applicant, and to my right is John Campbell.
Thank you.
Jeff, would you like to walk us through, and if you need anything, are you able to screen share, or if you're
No, if you
needing
could
to, just
handle
let me
that.
know.
If you could handle that for us, Aaron, that would be ideal. So I'll walk you through what we're proposing. This is for the site of the Madison Winter Club. My client's under contract to purchase it, and what he'd like to do is to convert the Winter Club into a year-round restaurant facility. The site is located in an R1 district at 251 Boston Post Road, and has been owned by the Winter Club at least for the last 55 or nearly 55 years, and operated as a seasonal facility, including dining services, for probably over 40 years, 50 years. What we applied for is an amendment to the regulation to permit a restaurant in the R1 district following the submission of a special exception permit, a special permit exception application to the commission. Prior to submitting our application, Mr. Lulaj invited the neighbors, the adjoining neighbors, to meeting at his facility, his restaurant La Foresta in Killingworth. There was a substantial number of neighbors who turned up. The questions that they had, they were generally favorable to the request. They had some questions and concerns with regard to things that you would expect, lighting, noise, landscaping, those types of things, but were generally supportive of the requested amendment to the regulations. They did request that the property right now has a entrance onto Boston Post Road and an entrance onto Stonewall Drive. One of the requests that the neighbors had was to close the entrance off onto Stonewall Drive, which my client is agreeable to. While the property is in an R1 zone, we believe that the use that we're proposing is largely in keeping with the use of the site as it currently is operating. Obviously, the Winter Club by its name is seasonal in use, whereas what we're proposing is a year-round use of the site for dining purposes. But the character of the use of the Winter Club has been, in large part for dining and serving meals and gathering of small and large groups of people, which is what Mr. Lulaj would continue to use the site for. So don't think we'd be introducing a use into the district that is not already fairly well established along the Boston Post Road and with in context with the and is familiar, a use familiar to some degree, to a fairly substantial degree, I would argue, to the neighbors. Across the street and slightly towards the center of town is the old schoolhouse deli. Across the street and closer to the west, or on the west side, is J&J Auto Repair. So there is at least some non-residential use in the proximity of what we're proposing. And while it is not a residential use and it is a residential zone, what we're asking for is the special exception for this site to largely keep what's been there, although admittedly it would be an expansion of the present use. The language in the text amendment that we proposed was drafted in a way that tries to remain in keeping with the practice of this commission that had been followed for a number of years, most recently in 2002. There was if you look at your special exception regulations, section 4 of your regulations in the appendix, there are a substantial number of similar types of exceptions that were granted for site-specific use throughout the town, where this commission felt that the proposed use was beneficial to the residents of the town, although it may not be entirely in keeping with the use of the district where the proposed use was located. We would ask that the commission adopt a similar posture with regard to this application, and for the reasons that I mentioned, the non-conforming use as a facility, although the regulations do provide that a club is a permitted use by a special exception within the R1 zone. The argument could be made that the Madison Winter Club is a club and it's being used as such. In theory, I suppose my client could submit an application to use the site in its present configuration as a club. Logistically, I don't know how that would work in terms of requiring diners and their guests to become club members before they could sit down for a meal at the proposed restaurant. But we felt it was more transparent to call the proposed use what it is, which is a restaurant, rather than characterize it as a club and then use that as a way to comply with the regulations, but maybe not be entirely in keeping with the spirit in which the designation was incorporated in the regulations initially. So that's the genesis of the application. We, as I say, we tried to follow the types of amendments that have been adopted by this commission previously. We feel that the use that's on the site is somewhat non-compliant when you look at the residences to the rear and behind it, but it is a permitted use. What we're proposing is to continue that use. We've reached out to the neighbors. We've submitted some correspondence in support of the application, which perhaps Ms. Mannix could share with you. And we think it would be, what we're proposing would be well received by the community. It's located on the primary commercial artery through the town. There are some commercial uses not too far to the west of the property with the car wash, Nick's restaurant, the plaza. There's the Auto Works and the old schoolhouse deli, which I believe still serves sandwiches across just up the street. So we don't think it'd be entirely, we're not asking, in my opinion, to insert something in an area where it would look entirely out of place. And so we think that for those reasons, we would ask that the commission adopt the regulations, the proposed text amendment, with the understanding that if you do amend the regulations as we requested, we will need to come back before you with a more detailed plan of what we're proposing to do. And at that point, the commission would have authority to address topics that would be a concern with the neighbors. We intend to address those in preparation of the application, but things like traffic, entrance, exit, lights, hours of operation, landscaping, all those things that would typically be considered in a special exception permit application you would then have the opportunity to address in greater detail. So this is really, from our perspective, kind of the first step towards getting the restaurant approved by this commission. So we'd be happy to answer any questions that you have.
Erin, I'm wondering if you could, can you pull up the map, or can we see the property?
Sure, I can share the location. Jeff, I don't think you submitted a map, did you?
I don't know as we did. I believe there's
I can pull it off of
in
GIS.
your memo that you prepared.
This is the subject parcel here. 251 Boston Post Road. Boston Post Road runs along here. You'll notice this is Neck Road intersection and Stonewall Lane here. I can put the aerial on if that's helpful. You can see the location. This is the Neck River coming through. I can zoom in here a little bit for you. Existing curb cut here on the bend of the Post Road. There's a second here, as well as a third on in this portion here on Stonewall Lane, and parking area as well, and a one-way driveway around the building.
And you can see J&J Auto Works is at 240, and then on our screen there's a reference to an app, but you can see at the intersection of Neck Road and Boston Post Road, where that little triangular piece is where the old schoolhouse deli. So those two uses are in close proximity to where the rental club is.
And also I have a question actually about the lots, because there are references to lot 3 and lot 2. And also I think you're stating that the property contains 51,400 square feet, but I think on our vision assessment, it's listed as 2.34 acres rather than like 1.18. So
it's 2.4 acres. Yeah.
It's 2.34 acres.
Yes.
Okay, so I think that the square footage is maybe not accurate. And so on the northwesterly corner, there's a lot 2. Erin, do you know, can you point that out to us?
Lot 2, so this is northwest here.
Right, right.
Are you saying that there is a separate parcel here?
I
What
don't
are,
know.
what are you referring to, Carol? I just want to get on the same page.
Yeah, I'm reading from the language, the proposed regulation change language.
The legal description of the lot.
Oh,
Yeah.
yeah.
Jeff, maybe you can
Yeah,
speak where that came from.
that's the description that's on the land records. It's not the GIS map. That's from the deed into the Winter Club when they purchased the property.
Does that reference a map number? I can pull that up.
Let's see.
Yeah, there's a map number 1090.
Okay, I can get that.
No, that's the assessor's map.
Just want to make sure we're all looking at the same property as defined. On the Madison's assessor map, Erin, it's lot 53.
Right. I have. This is the map that's referenced for the deed. This is what's filed. This is map 1090 from the land records. This is showing the parcel here.
I believe it's that triangular piece.
So these are the lots 1, 2, and 3. That's probably the lots that are, they're the
Right.
developers lots from that subdivision that are referenced in the
Okay.
legal description.
Okay, thank you.
Sure.
Erin, are there any comments from the town or town agencies?
Yes, I do have a staff report that I can read into the record if the commission is ready. Sure. This is dated May 19th, 2022 to the Planning and Zoning Commission from myself, Erin Mannix, Town Planner. regarding application 22-12, 251 Boston Post Road, map 35, lot 53, R1 district. Petition for regulation amendment to Madison zoning regulations, section 4, to allow restaurant use. And I can screen share this so that everybody can see that. I apologize. Everybody see that?
Yes, thanks.
Sorry, I have a new computer set up here. That's that's a little challenging. The applicant is proposing a text amendment to zoning regulations to add section 4.1.46, specifically allowing a restaurant by special exception with a series of conditions at 251 Boston Post Road, located within an R1 residential zone. The subject parcel is 2.3 acres and is currently used as the Madison Winter Club. A club is allowed by special exception in a residential zone per section 3.4 of the zoning regulations. A restaurant is not a permitted use in a residential zone. Connecticut General Statutes section 8-2 provides the statutory basis for the adoption of regulations by commissions. In enacting or amending regulations, the commission is acting legislatively and not administratively, and therefore has broad discretion. There is a two-part test to apply to determine if the commission's legislative action is proper. The first is the action reasonably related to the police powers purposes set forth in General Statutes 8-2. Second is the action in accord with the comprehensive plan of the municipality. Under section 8-2, the commission, as your combined planning and zoning commission, must make a finding that the regulation is consistent with the plan of conservation and development, your POCD, often referred to as the master plan. As you're aware, the plan establishes recommendations for future development of our community. The zoning regulations are one of the tools used to implement the plan. The comprehensive plan should not be confused with the master plan. The comprehensive plan is not a document, but it's found in the scheme of the zoning regulations themselves and the zoning map. The purpose of the comprehensive plan requirement is to ensure that zoning commissions do not exercise their discretion in a manner that's arbitrary, unreasonable, or discriminatory. The zoning map below identifies this portion of town and the subject property as R1 Residence District. A copy of the zoning regulations, section 3, is attached for your reference. And as I mentioned above, a restaurant is not an allowed use in the residence districts. Madison's 2013 POCD in section 7 identifies this parcel and surrounding area in the future land use plan below as medium density residential, meaning an area where residential development is expected to occur at less than 1 unit per acre. And here's the parcel. Section 8-2 includes a uniformity provision that is meant to provide a level of consistency through the district. All such regulations shall be uniform for each class or kind of buildings, structures, or use of land throughout each district. But the regulations in one district may differ from those in another district. Please note that floating zones and other overlay zones constitute an exception to the uniformity requirement. Supreme Court has upheld the creation of a zoning district as a planned development district, or PDD, as they were found to be similar to the creation of a floating zone. This is significant for municipalities for the discretion allowed in the creation of floating zones and the approval of specific uses within them, which might not be otherwise be available in the underlying district. However, this pending application proposes to introduce into the zoning regulations the special exception use of a commercial restaurant on one particular parcel in the R1 residential zone. Question is raised as to how this proposal demonstrates uniformity through the residential district or conformity with both the master plan and the comprehensive plan of the town of Madison.
Thank you, Erin. Do any commissioners have any questions or comments at this point? Yeah, John.
Yeah, I'm not familiar with a floating zone. Could Erin, maybe you could describe that a little more?
So that's an overlay district, essentially. An example of that is like a historic district overlay, or this planned development district zoning that we have currently in our regulations. So that is an option where the commission can, the way it functions is an application for a map amendment would be made, and at the same time, a master plan for development of the property would be presented, a conceptual master plan. In looking at that overall development, then the commission could then make that that map amendment, and the applicant further then apply for a site plan approval for that use. And then any changes essentially to that master plan would require a return to the commission, where you would then be acting in that legislative capacity again to review that.
So is that in effect rezoning of a particular piece of property?
It is. It's an overlay. Yes, it's a map amendment specifically.
Okay.
And so then that allows the application of specific zoning regulations to that particular parcel.
But Aaron, isn't that perpetuating the notion of spot zoning by doing that?
The courts have found that that is different than an overall. I mean, there are similarities, yes, where, you know, potential redevelopment, and that's something that the commission had looked at when you established your PDD regulations, where that type of use or that overlay could apply. Currently, our regulations only allow that in one general opportunity area at the intersection of New Road
Right.
and Horse Pond.
So if we adopt this amendment, then presumably anybody could come forward in any R1 district with a proposal for a restaurant. Is that right? And we would have to review it for a special exception every time. Is that correct?
This application is for one particular property, as Attorney Beatty had.
Okay. Oh, okay.
This
So
is,
I misunderstood. It's not for a general amendment to the,
this is a text amendment to your regulations to allow for special exception use of a restaurant on this particular property only in an R1 zone.
okay. Thank you.
Sure. And Jeff, if you have anything further you wanted to.
No, that's exactly what we're proposing. That it's just for this site, and again, just at the risk of beating a dead horse, it's because the site is being used as the Winter Club now that we wanted to continue to use it effectively in the same capacity. Obviously, expanding it to year-round use, but using it for dining and for restaurant purposes, but only. We drafted it so that it would only be applicable to this site.
Do we have examples of a similar situation in an R1 district? Has anyone done this before? I guess I'm wondering if this would function similarly or practically to us for changing the special exception rules. If people would then just say, oh, well, you did this in this lot, what's the difference between that lot and my lot that I want to turn into a restaurant? So I'm just curious that there is some precedent for this already, or if this is the first that we know of.
I don't know if there's precedent with regard to restaurant use specifically. As I mentioned, if you look at the appendix B to your section 4 special exceptions of your regulations, there are a number of instances in the past where the commission has adopted language that would allow uses within certain districts of that were proposed by an applicant subject to special exception. There was one, the most recent one was a mixed residential commercial condominium complex. I don't know the exact address of it, but that was the model that I tried to follow in crafting this proposed text amendment, to use something that the commission had used in the past. Admittedly, not in the recent past, it was 2002 that the most recent example that I could find was done. But there is a history of the commission making amendments to the regulations to allow proposed uses by special exception permit, or uses that the commission thought were suitable for the town in those locations that were proposed.
That is correct. There is section 4 point, it's in section 4, essentially 4.1 on are examples of specific special exceptions that were granted throughout town. Some of these date back to the 70s, and as Jeff indicated, somewhere in the 90s, when the zoning regulations, if anybody was here at the time of rewriting or updating the zoning regulations, they were all consolidated into one area because I think it was challenging for the commission to know what exactly to do with these. So at this point, they're as I indicated in my memo, it does kind of balk in the face of this uniformity requirement of the statutes, and it would be I think it's been several years since the commission has approved any such type of use. It would be staff's opinion that moving forward, we find a way to come to terms with this section and rectify or codify a little differently how this was done. But generally speaking, I think there are better practices to update the zoning regulations.
And I'm not disagreeing with what Ms. Mannix was saying. I was just trying to follow the practice that this commission had adopted in the past when we presented this. That's the reason it looks the way it does. And so if the commission were to adopt a different way of coming in with this type of thing, whether it was the overlay zone model that Ms. Mannix mentioned, then that's something that we would have. That would likely have been the type of application that we would have presented to you to achieve this goal.
I have another, go ahead, John.
Thank you. Just to make sure I understand it, if a special exception is granted, Aaron, that special exception, does it apply to this application or does it apply to the property? It applies to the application, is that correct?
No, so at this point, the applicant is seeking a text amendment to the zoning regulations to insert this language into the special exception zone, thereby allowing restaurants by special permit on this property. Then the applicant or any subsequent, anyone would make application for special exception to permit a restaurant on that particular property. So in that sense, that's when you would be acting administratively, reviewing.
Okay, so but in any event, any application for the use of that property would have to be reviewed. In other words, if for example, Mr. Ludlaw's application was approved and he opened a restaurant there and operated it for a number of years, let's say, and for whatever reason he stopped operating that restaurant and another owner came along and wanted to open a restaurant there, that would involve another application. Is that true?
Not necessarily. If it were just a replacement occupant, I mean, if the text amendment stands and for example, this particular applicant moved on and wasn't interested in this regulation, in this restaurant use, then potentially another party could come in and apply for a special exception to put a restaurant on the property. It doesn't necessarily mean that would be in this particular building. It means that restaurants are allowed by special exception. So whether that's a sit down, formal restaurant, a fast food restaurant, its restaurant is a restaurant use, and that being an allowed use in that particular property in the zoning regulations that would run until there was an amendment made to the zoning regulations. And then once a special exception is granted for the property, then that runs with the land.
With the property, okay.
Yep.
So we would be fundamentally changing the character of this property from something that is sort of the sleepy winter club to something that could be any level of retail restaurant operation, including anything that's a successor. So picture Chuck E. Cheese coming in there down the road, or what?
So not necessarily retail,
I didn't mean
specifically
retail,
for
not
a restaurant use, regardless, whatever. Yes, it could be a variety of types of restaurant, yes.
So we would permanently change what this property is like if we grant this text amendment.
Not by granting the text amendment, by granting the special permit application. The text
Oh, we're changing our text.
Right, but what you're doing is you're allowing the applicant to present an application for a special permit exception, at which point the commission has a fair amount of discretion in terms of the conditions that it attaches to any approval it would want to give to the applicant. So if you wanted to grant the special permit exception application, for example, but you said on the condition that the property not be used for drive-through service, for example, you could attach that condition to the approval, and then that condition would run with the land on the property, or that you had to have, a set number of tables or seats or square footage. There's a number of conditions that the commission would have available to it to restrict the types of activities that could be used on the site. So yes, you would be permitting an applicant to come forward and satisfy those criteria if you adopt this text amendment, but you would still retain control through the special permit process to regulate exactly what type of restaurant gets constructed there.
I have another question, Aaron, I think, to ask you, what would happen if a subsequent owner wanted to convert it back to a residence in an R1 district?
An R1 is in an R1 zone, a residence is an as of right use.
But if this is
We
changed,
require permits.
if this language is changed in the regulations so that this property is now a restaurant, zoned for a restaurant.
The regulations change to allow by special exception. It does not eliminate any of the permitted or other special exception uses in the zone or permitted uses that already exist in the R1 district.
That's exactly right. This amendment is intended to add an additional use to this site in the R1 district. It's not intended to extinguish any of the other uses that are permitted on this site or any other site in the R1 district. And so one of those, as I mentioned earlier, is the right to use the property as a club, which is why the Madison Winter Club is a compliant use of the property. And why, in theory, my client could open, La Foresta Madison Club and have people become club members in order to dine there. But as I said, he'd rather not do that. We're trying, as I mentioned before, we're trying to be transparent with the intended use of it rather than use your language to kind of avoid the issue and skirt around it.
Any other questions from commissioners? Giselle, do you have any questions?
I do not.
Or Elliot?
The only question I have is regarding the winter club and the current exception that's in place for that property. Is there any guidelines is regarding what is actually considered a club? and like anything regarding like number of members or anything along those lines that are permitted?
I don't have the special exception in front of me. I don't recall. I can tell you that it is a special, excuse me, a club is a special exception use throughout all of the residence districts. It's not a special exception specifically for this particular property. So just to clarify that point.
Okay.
Let me see, I may be able to pull one up for you.
So if it were reopened as a different type of club, it would still have to come in front of us for special exception application.
Special
Good.
exception runs with the land. So if somebody, if it's just a replacement occupant under the same the same parameters of the original special exception, then no, that does not necessarily require them to return to the commission to occupy that space as a new club. If they were looking to make site plan amendments, or if there were conditions applied to that special exception that they were looking to modify, then that would require a return to the commission.
Thank you.
Do we have any attendees who would like to ask questions for clarifying questions?
Mr. Campbell literally raised his hand.
Oh, I'm sorry, I didn't see that. John Campbell, 101 Randy Drive, Page Staff Compass Real Estate. Just curious, did any of the neighbors object to the application?
I'm sorry, I
We
couldn't hear you.
Oh, my question was, did any of the neighbors object to the application,
Are you referring to written correspondence?
written or verbal?
Well, we haven't gotten to the public comment portion this evening of the hearing. Looking in the documents attached on the website and associated with this file, there are letters that are shown in support. I don't see any letters, written letters in opposition.
Yep, they're letters of support, but I don't
They're
think.
not
they-
abutters though.
Yeah, they're not from the neighbors. There are 11 letters of support, but I don't think any are abutters or neighbors, immediate neighbors.
Other than John Campbell's letter.
Right. Well, I had called a few of them today to see if they were going to attend the meeting.
Mm.
And one couple's in Italy, one's too elderly to actually use Zoom, but they said I could use their names if requested to show their support. But I didn't receive any. I didn't actually. I should have asked them to write some letters. I did not.
Madam Chair, I do have two members of the public with their hand raised. I think you were on questions at this point.
Yeah, we would like clarifying questions, not a position of whether you're in favor or against yet.
Okay, I have Joanne Wilcox. Joanne, if you could just identify yourself for the record.
Hi, I don't know if you can see me. Can you hear me?
Yes, we can hear you.
Okay. I'm Joanne Wilcox. I live 481 Warpus Road, Madison. I am also the president of the Madison Winter Club. And I have a little history knowledge with the Winter Club in that prior to the Winter Club purchasing that property at 251, that property of 251 was a restaurant called the Carriage House. And it was a year-round restaurant, and then it became just a summer-only restaurant. And then by the members of the Winter Club back in the 1950s, purchased the property from that. And they used it in the summertime. The Carriage House reopened, and in the wintertime, it closed and the Winter Club took place. So I just thought that might add a little knowledge to the history of that piece of property. As to just small comment I was going to make as to the Quiet Winter Club, it is now, and that is why we have had to close it. But at one point, the Winter Club had over 350 members, so that was quite an active club. That's all. Thank you.
Thank you.
I don't have anyone else with their hands raised for a question.
If I could just add something, in looking at the description that was attached to the application, I would just want to check that against the map that Ms. Mannix submitted earlier before the final amendment is approved, just to make sure we've got the right property description on there. I would like to double check that just before it gets, I want to make sure it's the correct meets and bounds description, so we're not amending it with the incorrect description. I think it may be accurate, but I do want to double check that.
Okay, thanks.
Madam Chair, I have another individual with their hand raised, Steve Straka. Steve, can you identify yourself for the record, please?
He's muted.
Can you unmute yourself, Steve?
Can you hear me?
Yes, hello.
Sorry about that. Yeah, hi, it's Steve Straka, 16 Deer Run, and we live directly behind the property. And we're just curious to understand more about the noise levels and hours of operation and lighting and things like that. Obviously, there's some concern, we're not opposed, but we do want to understand more about what controls would be in place if it were to move over to a restaurant.
Would you like us to respond to that, or? Okay,
Sure.
okay. So in connection, so tonight's application is not the approval of the the proposed use of the property specifically with regard to the my client's intended use of the property. What it is the approval of an amendment to the zoning regulations that would allow my client to make an application to the Planning and Zoning Commission for what's called a special exception. And that would result in another public hearing in front of the commission, at which point we get into the greater detail with regard to hours of operation, lighting, landscaping, venting, all those types of things that I think are your concern. So I'm not trying to avoid the question, but I just want you to know that this isn't really the forum where we would be addressing those topics. But that any application that we would make, should the commission approve the requested amendment, would then come before the commission, and there would be a public hearing at which we would address and we would submit a plan which would address all of those issues with regard to parking, lighting, noise, buffers, all that type of thing. So this is just the first step that would allow us to come back before the commission to present that application and answer exactly the types of questions that you're raising.
If Nick Robinson, his hand raised. Nick, can you identify yourself for the record and your address?
Yeah, can you hear me?
Yes.
You can.
My name is Nick Robinson. I live at 16 Stonewall Lane. Our property abuts the proposed property. I just want to say that we are in support of the change in the language with the zoning to allow a restaurant to be zoned there. We thought long and hard about what is as having our property right against this property. We thought about what would be best for the community and would be best for kind of the abutters. And we feel that by rezoning this to a restaurant would be lowest impact on our property line, and would be in the best interest to the community.
Thank you, Nick. Anyone else in support of the application who would like to speak?
I have Steve Straka again with his hand raised. I'm not sure if it was still for a question or not, Madam Chair.
Carol, are we still taking questions or are we getting people's opinions?
Well, because
That's good.
that's a good point. I did switch over to getting comments in support of the application since we started doing that with Nick Robinson's comments.
Steve, are you speaking in favor of this application, or should we hold off on your comments?
I think we're in favor.
We're okay with it.
Yeah. Can you, I'm sure I gotta hit this here. Yes, we're in favor, but we are concerned. You know, we just want to make sure that there's proper controls in place.
Thank you. Should we move on to any attendees who are opposed? Give them the opportunity to speak if there are any.
I don't see anyone else with their hands raised.
Okay. Did the applicant want to make any further?
Oh, I apologize. I looked down and now there's a hand raised. Ed Riley has his hand raised. Ed, could you please identify yourself for the record? You're going to need to unmute. There you go.
Better now?
Yes, thank you.
Yeah. I'm Ed Riley. I live at 33 Stonewall Lane. And as a neighbor, they presented some information to us. And I can't speak for other neighbors, you know, specifically, but most of us, or particularly myself and my other half, think this is a good idea for the town. Bring in taxes, and they have agreed to try to do some other things like close off the Stonewall Lane exit, which would be good. So from a standpoint of one of the neighbors, I would be in support of their application.
Thank you.
Thank you.
I have another Karen Rosenthal.
Hi there, Karen Rosenthal. I live at 13 Stonewall, and I'm just voicing support as well. No other comments, but I live right across the way in that neighborhood, and we have a problem with it.
Thank you.
Thank you, Karen. Are there any other raised hands? Any questions? Giselle, do you have a question? No.
I don't.
Any other commissioners have any questions? Perhaps then, should we make a motion to close the public hearing portion and move to deliberation?
I had a question for Attorney Beatty. You indicated you want to check the text language of your proposal. Is this something you're looking to do now during the hearing, or continue? What is your desire here?
Not at the moment, just to make sure I've got the correct description. So I don't know if that will prevent a vote from happening tonight, but I just do want to double check to make sure that this meets and bounds description is exactly accurate, because the last thing I want is to come back a month or two from now and say we've got to amend the amendment to get the correct description in there. Right? That was my main concern.
I'm sorry, Jeff, I didn't catch your last couple of words.
Oh, I wanted to make sure, if you could pull up that map again. What was it, 1090?
Yes. One second here. Were you looking for the boundary?
Yeah, I just wanted to make, it doesn't, in my description that I proposed, it has that, it references lot 3, which I don't think is the piece that we're talking about, unless that includes the entire piece. There is no number for the piece, including the winter, the clubhouse and the parking area. So I would ask that the commission amend the that the amendment be such that it reflects the meets and bounds description of 190 feet north, 63 degrees, 2 minutes, 56 seconds east along Stonewall Lane, south 24 degrees, 4 minutes, 31 seconds east along lots 1, 2, and 3, 1 and 2, and then 175 feet more or less along lot 3, and then 150 feet more or less along the curve of the center line of the Neck River, and then along the Boston Post Road, was it 456 feet more or less, and then 84.1 feet, and then 60.7 feet to the center line of the Neck River. That would be the meets and bounds description that we have to approve.
And then I also had a question about the square footage that you provide for the lot, which seems different from what we have on our other maps.
Within that description?
Yeah, within
No.
4.1.46, you described 51,400 square feet, which maybe I'm doing the math wrong. Maybe other people can back me up with this, but I think that's just over an acre, but the property is described as having 2.34 acres.
Right. I was basing it off of that lot number 3, and that the acreage isn't identified on the on that survey. So I would just say 2.53, 2.3.
2.34. So that language, I think we may want to clean up the language.
I think the legal description is of lot 3,
right.
Deer Run. So is this the description that runs with the deed for the property, Jeff?
I believe it is. That's what I just want to double check, because I just want to.
That doesn't make any sense.
We're getting it right. Yeah, because it's northeast.
Madam Chairman?
On Deer Run.
John Mather, yes.
I just have a question. I'm looking at this on a relatively small screen, so it's hard for me to see the detail, but are these lots that are depicted here as 1, 2, and 3, are they rectangular lots? There's also a line of trees.
Line of trees, yes.
Sorry. Okay, thank you.
And these are 3 residential properties.
Right. Which the Winter Club at one point owned, and then
Owned lot 3?
and then sold them off to the owners of the lots now.
So it seems there may be a discrepancy in the legal description that's on
what I
here.
wanted to get.
Yep, I agree with you. So, yeah. Okay. Madam Chair, Joanne Wilcox has her hand raised again. Are you still taking public comments here?
Sure.
Go ahead, Joanne.
Hi, it's Joanne Wilcox, 481 Warpus Road, Madison. As president of the Winter Club, I actually have copies of the deed when this property was purchased. And I can tell you that at least I know that those lots 1, 2, and 3 were owned by, at the time, were part of the Winter Club parcel. I even feel a couple more, but I'm not exactly sure. And those were sold off over the years. And it became the residence. So the Winter Club only owns the frontal part that is outlined in your picture there, the building and the land there, and the parking lot that is right against, that abuts Boston Post Road. That tree line is our back line. The lots 1, 2, and 3 were sold off, but we own them many years ago.
And my guess would be that the description, that there may not be a formal description of the Winter Club parcel right now, because it was one parcel when it was acquired, and then over the years, lots 1, 2, and 3 were conveyed off without there being an updated description created of record on the land records of what remains that's owned by the Winter Club. That would be my guess.
I think I would leave that up to you, Jeff, as far as how you'd like to leave that, if you wanted to look more into the title or the legal description of that prior to closing the hearing, if information needs to be updated.
Yeah, give me one moment to just talk with my client.
Madam Chair, I have a quick question while we're waiting, if I may.
Sure, John.
In regards to the letters that were submitted for this application, there was the first letter there is not signed or identified for anyone. And is it admissible?
I was wondering about that myself. Yeah, it's an anonymous letter with no indication of name or address.
Yeah.
I think the commission has the right to weigh that when considering the points in the letter, if it's not identified.
And similarly, Mr. Campbell's letter, which professes support from several of the neighbors, do we not need some sort of validation from those neighbors that he does speak on their behalf? I'm just curious about that.
I think that's also a question that you can
discuss,
or at least, weigh in, if you don't have an individual letter, you can take it at face value of,
Okay.
as we don't have any evidence of that.
Yeah.
But there's nothing, anything that is submitted on the record is part of the record. But you do have the ability to weigh those that are signed by individuals against those that are not.
So,
okay, Jeff.
Yep. So it's really what the commission feels comfortable with. We've got the meets and bounds description on the survey that's there. That's the piece that we're talking about. We can base the description off of the meets and bounds on that, and then I can submit a formal description to Aaron to review, to check to make sure it matches against the survey that we're all talking about. I don't think there's any question what parcel was intended, what the survey, with the lot map and lot assessor's map and lot number are map 53, map 35, lot 53, what the acreage is. So we're all talking about the same piece, but it's just making sure that the language as formally gets incorporated into the regulations is the correct meets and bounds description of it, which if I made a speaking description of it a few moments ago, and I think if we make reference in the minutes as to which lot we're discussing, that would hopefully make the commission comfortable with that. Otherwise, if you'd rather have it prepared in writing before voting on it, we can prepare a written meets and bounds description and submit that to the commission to vote at its next meeting. When it's entirely your preference. Assuming we're hoping that you'll vote in favor of the application, but we're happy to do whatever makes the commission most comfortable.
Commissioners, any responses? I think,
Yeah. It's pretty clear to me what the property is. I can't speak for everyone else.
yeah, I think because I raised it, I'm feeling that if this is a regulation amendment, I would like to get the exact writing, the exact language, and make the corrections and see the corrections. That's my feeling. But I'd like to hear from anyone else too. Or how everyone feels about moving to deliberation.
I mean, I think if we were to consider voting in favor of it, I think your opinion is very valid regarding having the proper boundaries and information on the actual lot be part of it. I think if we're leaning towards not approving, then it's probably a moot point to make them come back for an additional meeting.
Thank you, Elliot.
I agree.
Should we move to deliberation then? Could I have a motion?
Motion to close the public hearing.
Thank you, Peter. Second,
I'll second it.
any further discussion? All in favor?
Aye.
Okay, so the public portion of the hearing is closed and we'll move to deliberation. Applicants, you're free to leave or to remain with us. All right, who would like to lead the discussion? Peter, your box is lighting up for me. Do you want to start?
I didn't mean to, but I'll go. Actually, I'm not in favor of approving the text amendment. So that's how I'll vote.
Okay. Anyone else want to share thoughts and opinions?
I'll share my thoughts. I think the applicant runs a fantastic restaurant in Clinton. I would love to have one here in town because it is a restaurant that I enjoy going to. I just think making a text amendment for this piece of property, and it just is a little bit too much to me, like spot zoning, and I likely would not vote in favor of the text amendment.
Thank you, Elliot. Giselle, any thoughts?
I have a question. Can you explain what spot zoning is? I'm not fully understanding.
Erin, do you want to give your best explanation?
It's a concept of basically applying zoning regulations to individual parcels. Rather than, I think that speaks to the uniformity concept that I had talked about in the memo, in my staff memo of consistency throughout your zoning districts.
And having a comprehensive plan.
Mm-hmm. So I'm in favor of the text amendment for this property. I'm very much in favor, aside from the fact that I recently, for the first time, went to this restaurant and I was amazed and brought other people. And actually the owner who was sitting there served our table. Runs a great operation and beautiful grounds and beautiful restaurant. Would love to see another one in Madison, and we totally do need one. But aside from that, but I'm in favor of the text amendment for this particular property because this is what I feel we do as commissioners on P&Z. we look at individual applications and we make decisions based on either a particular property, a particular request, and in this case, it's the property. So my thought regarding another person just haphazardly coming and saying, hey, I'd like to do the same thing in an R1 district. Well, we would then, it'll be presented to the commission and we would then determine based on their property, what our decision would be as we deliberate. This property was a restaurant prior. This property also has the parking lot, the size, and all the potential, in my viewpoint, to be a great restaurant. So for that, I am in favor of the text amendment.
Thank you, Giselle. Shauna?
I'm struggling with this one a little bit because I think for all the reasons that Giselle laid out, you know, I think it would be a nice use of that property. But it does seem like it's a little bit out of the scope of what we are allowed to do, based on what Aaron had laid out for us, in terms of its uniformity rule. So I think I actually come down on the side of not voting for the amendment.
John?
Oh, it's a tough one. I'm very much in favor of a restaurant going into that building. I think it's a perfect use for the building. I think that the Winter Club was a restaurant. It was a supper club. It's what it existed for. They entertained and they dined there. And prior to that, it was a restaurant. The space is ideally suited. Even though it is an R1 district, I recognize that it borders with several other commercial properties all along the post road there. We've had 4 abutters and neighbors speak tonight in favor. I mean, how often do you have an application where the neighbors are almost unanimously in favor versus opposed, in addition to those that were spoken on behalf of in a letter by Robert. I also recognize the risks involved with the amendment, and so what I'm curious, Aaron, is are there any other options for us? Are there any other ways to look at that? I hate to look a gift horse in the mouth. I think that we have an opportunity to add a great asset to the town of Madison. Mr. Luja is a proven, successful, quality operator of a restaurant. I've been to his restaurant several times. I also happen to know he's an excellent civic citizen of Clinton, and he's benevolent. I think that would be only good for this town to have that business there. And I would like to know how we can facilitate that. And if text amendment is the only option, then I would be inclined to vote in favor of it. But perhaps there's another option.
I can say there's one option before you currently with this application. And I think I would leave that to the applicant's attorney to explore other avenues that may exist. Yes, but currently there are no other proposals before you, but a text amendment for special exception use for the property in a residential zone.
At this point, we can't ask any additional questions of the applicant.
Oh, I think we can.
No, the public hearing is closed.
Okay.
You're in deliberation, so there's no new information that can be submitted.
Erin, when would conditions of the special exception, when does that or how would that come into play? Does that come into play by approving the text amendment? Or if we had approved the text amendment, then we would go into discussing conditions?
There are parameters proposed within the text amendment before you now. 4.1.46.2 are conditions applicable to restaurant uses as proposed in the text language. As you're aware, during special exception process, and you do have the ability to place additional conditions on special exception applications at that time. You cannot condition a text amendment to your regulations.
So this amendment applies to, does it apply to all R1 districts? This proposed text amendment?
This is an application for an amendment to this particular parcel
Property, just this one
to
property.
allow for restaurant by special exception use only on this property in a residential 1 zone.
So if this amendment were approved, it applies only to this parcel. It doesn't apply to any other R1 districts that are not.
That's correct.
Correct. But it also opens the door perhaps to future applications similar to this. I don't know. I'd like to just zoom out a little bit too. I'm having a real struggle with this application tonight, and in large part because of hearing the abutters all support this. And I agree that, as you know, I think it would be a great restaurant use of it, you know, converting maybe from a club. But I also at the same time feel that we don't have enough information to know what that restaurant would be. And it is in a residential area. And yes, there are some commercial properties, but I do see it as an area that it's at the very end of a state designated scenic road, and in the plan of conservation and development, that area is referred to as a state road with scenic characteristics that we need to consider as part of the residential character. I think also it's a building with some history, some historic components to it, and that wasn't really addressed in the application. I'm also concerned about some of the safety issues of an increased volume going in and out of that parking lot. So I think, you know, as far as sort of the larger health and well-being or welfare of the entire neighborhood or that stretch of residential use, I have some concerns, some serious concerns about that. But I also agree that, you know, this restaurant owner has a great reputation, and some of the neighbors really support this use. So it's a tough one.
We're not approving the application for a restaurant, a specific restaurant tonight, right? If this amendment were approved, then an application would come for a restaurant, and that restaurant could be a McDonald's, it could be a La Fresta, or it could be anything, right?
Right.
And we have the right to consider and approve or not approve that specific application when it comes.
Right. That's
Aaron, can I ask you a quick question? It seemed as though your staff was concerned that this did not meet the criteria set forth for this conformity or uniformity, right? Would that open us up potentially, if we did approve, for someone in the town to bring a case, court case saying that this was a violation of the statutes of the town of Madison that could put this on? I'm just wondering if if we did actually end up wanting to approve this, and should we consider that as maybe a possible outcome if people really opposed this restaurant going in? It doesn't sound like that would necessarily be the case. I'm just wondering if that could cause problems down the road.
Any decision that the commission makes is appealable to Superior Court. So I think that's something you should consider in all of your actions.
Fair enough, fair enough.
Consistency, yeah. That's, I think as I have provided you with the parameters as prescribed in the statutes for when the commission makes text amendments to the regulations. If some, I can't say that somebody will appeal an application or will not. I think you should consider, yes, and weigh the pros and cons prior to your decision making, and have some findings to support your decisions, so that should an appeal be taken, that our land use council can represent you well in court.
But Aaron, in this case, we also have broader legislative powers, correct? Because we're talking about changing the regs as opposed to something that's administrative.
You're correct. There is broader discretion in legislative, when you're acting in your legislative capacity, than when you are acting in administrative capacity. Administrative capacity is the approval of a special permit.
Correct.
Plan, things like that.
Would anyone like to make a motion on this application?
Do we think it requires additional deliberation, maybe some discussion with council? I don't know. I mean, Aaron's given us some good direction, obviously.
Yeah. I don't know, but I will add that I'm not entirely comfortable approving this with a language that may not be the final language. Just on that detail, I'm uncomfortable. I know, John, I think you're asking about bigger legal issues perhaps, but.
Well, I'm sensing that myself, and from what I'm hearing from those who have spoken, that this requires a lot of thought, a lot of consideration. It is precedent setting in a way. I think I'm comforted in the fact that it applies to a specific piece of property, and is not broader in scope if we were to make the amendment, if we were to approve the amendment. But and I don't see a tremendous amount of inherent risk. However, that could be my own naivety.
Any further thoughts or comments?
Well, Carol, you took a little bit of a straw vote, so I think that's kind of how the motion has to run, correct?
Yes, I'm
I
happy.
mean, so, I mean, you might want to poll everybody one more time, because if it's against, then we'll use language. If it's for, we'll use different. But right now, it's not clear to me. Well, it seems to be leaning towards no, but that may not be accurate.
I'm leaning toward no. Shona?
Wow, now I feel like the really important vote. I'm going so back and forth on this. I think actually I'm leaning more towards yes now.
Elliot?
I'm still leaning towards no, but piggybacking off what John said, I do think it would be a good use for this property. I just hope if we do vote against it, that they do come back with another plan to, other than a text amendment, to make this happen. I'm just not really comfortable with making that text amendment because I just consider it to be a little bit too much of spot zoning for one particular parcel in a mix of all residential properties.
Giselle, I think you were pretty clear.
I'm a yes.
And John, still
I'd be a yes.
not sure. We have pretty close tie with many of us kind of wavering here. Do we feel comfortable taking a vote?
Well, we actually have 6 on today.
Yeah, and I think that was a 3 and 3.
If it's 3 and 3, it doesn't pass, correct?
No, I believe it needs a majority
Yeah.
or a, yeah.
Maybe we should discuss what the discomfort is and see if we can get more information or legal counsel or someone to give us more information.
Well, so the public hearing is closed, Giselle. So at this point, your legal counsel is your only source of information. But ultimately, if you have specific questions, beyond what I provided in the staff report regarding the statutes, if you had a specific legal question, we could reach out to counsel. But ultimately, it's the commission's decision to make a determination.
Okay.
I think then we should make a motion and go ahead and vote. Anyone willing to go ahead and make that motion?
I'll make a motion to approve the text amendment for 251 Boston Post Road text amendment.
Thank you, Giselle. And do we have a second?
I'll go ahead and second it.
Any further discussion before we go and take a vote? All right, all in favor of approving it?
Aye.
Aye.
Opposed? 3 of us opposed and 3 in favor.
Motion doesn't carry.
Motion does not carry. With very mixed feelings, the motion does not carry. All right, then. So I think I need a motion to close this. Is that right, Erin?
Just to move on to the next.
Move on to the next agenda item.
Thank you.
Under our regular meeting, we have a pending application for 45 Wall Street, 22-06. And I believe they've requested granted an extension to June 16th.
That's
Karen?
correct. An extension was granted to June 16th, which is the maximum amount of time of extensions that can be granted to the commission to hold the hearing open and act. However, in conversations with attorney Chris McKeon, he did indicate that they would likely be ready to return to the commission at your June 2nd meeting, and is asking that although the extension was granted, they would like to reopen the public hearing at the June 2nd meeting. So we would just need a motion to do that.
I'll make a motion to move it to the June 2nd meeting.
I'll second.
Second. Any discussion? All in favor?
Aye.
To me, I think we'll have more people there. Great, okay. And we're in receipt of 09-05D and 09-06D and CSP 14-08, 67 Boston Post Road, with another request for an extension. Do we have representatives here to speak for them?
Chuck Mandel, for the applicant's engineering and surveying firm is here. No, Chuck, I don't see Bob or Mr. Altieri here. Are you able to speak on their behalf?
Yes, Erin, Chuck Mandel, agent for the applicant. I can address some of the comments, not all of them. So we can either ask for continuance and meet next month, or we can address some of the issues that are outstanding tonight. I believe our permit runs out at the end of this month, if I'm correct. The original approval was June 18th in 2009. We are seeking an extension to June 18th, 2023, just to take care of some of the deficiencies. I am in receipt of a list of items that are that we can address, that I can speak to tonight, specifically storm drainage, erosion control measures, that type of thing. I know I was out there this week. In fact, we did stake out some of the drainage, and LaFata and Son was out there, and they did install some of the drainage for the detention basin that was in. So that is in fact working right now. There are other issues. The builder has been plagued with supply issues, labor issues. This past couple of years, the past 2 years have been pretty rough for him due to extenuating circumstances, which we all know about. So we are seeking an extension. He is working on fixing these deficiencies. Right now, the last building, there are actually 6 units, 6 buildings, and it's 15 units total on the Boston Post Road side. It's actually in 2 phases. There is another section on Wildwood, which consists of 2 buildings, and that's an additional 5 units, which he has not started. So that is a section that is in the process. So at some point will get developed, but that's something that can be held, I don't want to say held hostage until these deficiencies are corrected, but it certainly can be part of the strength of the commission to deny any further use and deny him those 2 buildings until these discrepancies are taken care of. And I would ask the commission to allow us 1 more year to extend the permit, and so we can take care of these deficiencies. Like I said, he is actively working on it right now. There are some issues regarding affordable housing nuances and percentages, and I'm not able to speak about those. But in regards to the site work and complaints by the neighbors, erosion control, we are in the process of addressing those fairly aggressively right now. So that's really all I have to say in regards to that. And if there are any questions, I'll be happy to answer.
So I can just speak to some of these items here. I did provide you with a memo. I can inform the commission that we have, and I have received calls and emails from residents of the development who are concerned with the status of improvements, as well as the length of time that the application or the construction is taking. So with respect to the timing, when the applicant was before you last year, the statutes allowed for site plan approvals. They were amended back in 2008, 2009, I believe, in response to the recession, where you would typically have a 5-year period of time for site plan approval. There were amendments made to the statutes to allow for a 9-year period of time if a permit was issued and valid between certain dates. Okay, so this particular property or this particular application falls within that that time frame because it was approved in June of 2009. So last year in January, when the applicant came before you, he was beyond the 9 years, and the commission had discretion and was able to grant extensions for up to a total of 14 years in one or more extensions. So the maximum amount of time that the site plan could be approved for was 14 years. Now, going back to July 2021, the statutes were amended further as part of the implementer bill. And those regulations where an application was valid from for a total of 9 years, now that bumped to 14 years. So this particular development falls under that realm. And now the statutes mandate that a site plan approval shall be valid for 14 years with an additional 5 years at the commission's discretion. So here we are where now you're mandated a year later because the state laws have changed that you shall approve an extension to June 18th, 2023. However, the regulations also, as we can see, there are outstanding site improvements. And in my opinion, some of these should have been the first thing that was installed on the property when I'm looking at that. The detention basins, we have multiple buildings that have been constructed on the property. We have impervious surfaces as far as driveways and shared access ways, now all contributing to increased stormwater runoff, and none of those improvements were installed to address that increase. This was a coastal application as well as an inland wetlands application. So there are natural resources that can be directly impacted by this additional runoff. So it is, in my opinion, it's a step in the right direction that these improvements have begun since our meeting with some of the residents and as well as the builder and Tom Stevens' office. That being said, let's see, there were also access requirements from the DOT permit as well, which included basically a pull-off kind of widening area on the Boston Post Road. That those improvements, although they're bonded with the state, those have not yet been completed. The landscape plan, there's questions as far as what has been installed per the approved plan. As I said, we just have a binder coat down now for the parking, the driveways and the common shared access ways. So we have not received from the applicant or the developer an as-built with respect to the drainage system to show what's in, any sort of verification that what has been installed at this point is actually in compliance with the plan. Some of the concerns relate to roof leaders and some stormwater infiltrators. There's also some additional landscaping screening that's been installed on the site in between units that may not necessarily be part of the originally approved plan. The commission does not hold any financial sureties for this development. It is not permissible through the statutes to accept a performance bond up front for the value of all of the improvements. There is the ability of the commission when an applicant is looking or developer is looking for the CO for a property, that those site improvements be completed. If those improvements are not completed, for example, this happens sometimes with single family houses or or construction projects in the wintertime, where you may not necessarily be able to get landscaping in during the growing season. They have the ability to bond for outstanding improvements as a financial surety that, you know, come the better weather, the warmer weather, those improvements would then be made, and that's the commission's basically your insurance there, that should the applicant not complete these improvements, then there is an opportunity for the commission to step in to call that bond through a public hearing process and then have that work completed. In this particular situation, it's relevant. I mean, we have 12 units that residents are occupying. It's an ongoing construction site, which is legally permitted. However, some of these are, as I said, the stormwater system is a drainage issue. There are some questions regarding vehicular safety, the lack of striping or you know, stop bars or stop signs on the property. Those are things that, in my opinion, should have been addressed early on prior to anybody living there. So and lastly, you know, the town, as this is an affordable housing project, the town has a vested interest in the completion of this project and to make it a successful project, because we will be gaining 6 affordable units out of this development. Currently, 4 of them are affordable and have been completed. This last building, it's my understanding that there's a contract purchaser for one of the units, and the second unit in that building is one of the affordables. In my opinion, I would suggest that the commission, and maybe my first suggestion would be to hold off on any extensions or further action until the developer, the property owner, has an opportunity to discuss this situation with the commission here at a meeting. It's a little disappointing that he is not here this evening to address some of our concerns, as well as compliance with the affordability plan that was submitted. And that those are questions, as Chuck indicated, that are not in the realm of engineering or surveying that they can answer. And that may likely have to come through the developer's attorney to address some of those concerns. I would strongly urge them to come to the next meeting to address these items. And I would also urge the commission that moving forward, you know, the statutes do require that a 1-year extension be given. However, you may condition that to require that site improvements be completed prior to the issuance of any further certificates of zoning compliance. And now the developer has a deadline, essentially, with a contract purchaser to really step up activities here and get some of these shared improvements completed on behalf of the residents and the project in general. And then if by chance some of those, you know, some of them may get done, some of them may not. There's a strong likelihood that some of these improvements would not get done prior to the next closing. And at that time, I would then say that the commission could consider a financial guarantee offered by the developer for any of the remaining outstanding improvements. That way, if by chance the project fails or there are extenuating circumstances, the town does have the ability to call the bond and have the remaining improvements done. At this point, we really have no ability to step in or ensure that this project gets completed, at least the phase 1 end of it.
Aaron, I have a quick question. So this, the permit expires, what's the actual date that this expires? Is it the end of this month or is it June?
Statutorily, it would be the actual approval. The statutes authorize it until June 18th, 2023. Now, I think there needs to be a formal action by the commission extending to that date, since their previous extension last year brought them through, I believe it was through the end of this month. So I do think it's reasonable that the commission, you can continue this discussion to the next meeting. I think it would be helpful to have Bob here. And I'm sorry, I can't remember Mr. Altieri's first name.
I don't know.
Okay,
No, that I don't know.
Mr. Murphy and Mr. Altieri, who
Right,
who
okay.
are the property owners, to come and address the commission and speak to you directly to give you an idea of what this timeline is,
Well, specifically, I can address the engineering aspects of it. So, like I said, they did complete the drainage basin. We can certainly work on as-built. This letter that I received, is it May 10th, Erin?
Yes.
That letter, yeah. So a lot of times what happens is the engineering companies get blamed for what happens on the development. We really had not been involved with this project. We had not gotten a call from the developer almost until we received this letter, and then it became a crisis. So I don't know how that happened, but now that he's in scramble mode, I don't see the downside. I mean, we do have the till 2023, June 18th, statutorily, just to continue the work. I know the developer wants to keep things moving, and I will implore him to be at this next meeting to speak up and address the affordable aspect of it. But I think so June 18th, 2022, Erin, if the commission, and I'm a little confused, they said statutory, like they have to give us the extension, but they could do it with conditions, or?
So right, so the site plan can be valid until June 18th, 2023.
Okay.
However, the commission does have the ability to put some pressure on the applicant.
Right, I totally agree with that. I just didn't want a cease and desist order when you have people living there and it sits there vacant until some shark comes in and tries to buy it for 50 cents on the dollar, and then does do the improvements, because that does happen quite often. So
it's a fine line, I think.
Yeah.
I mean, especially if, and I would leave that to the applicant to discuss, but if there are financial challenges in completing a project, to require bonding up front is taking money away from putting it into the actual.
No, I'm just speaking to getting the work done,
right, and not
the infrastructure. Correct.
Right, and not extending an application. I mean, you're bound in this particular case where you don't have a lot of discretion in extending it. But had we been in 2023 and now you have discretion, I mean, it's in our best interest to keep moving forward and getting this project done.
That's exactly what I'm talking. I didn't want it to stop. And, because, there's a cease and desist order on us. But as long as we can continue working, I know Mr. Murphy has been calling us to get property lines staked out. We'll work on drainage as-built, track down all the stormwater systems, get everything on paper so staff can review it and make sure it is in compliance with the approved site plan.
So, Chuck, do you have an estimated, is all of the stormwater system in now?
Yes. Yes.
All the galleries are in, along the western,
all
on
the
the western side.
All the street drainage is in. I don't know about the individual structures. That I do not.
I didn't think those were in. There's a separate infiltrator at building 1, as well as along the western property line.
If they are in, Erin, I was never called in to do the as-built. So we would have to go back and see if they were in. If they are in, I'll have someone go dig them up so we can get inverts and get the actual sizes.
So maybe it would be helpful to have a circle, you know, to see as many of these and to reach out to Mr. Murphy directly to address the status of these 8 items that I listed in our memo for this next meeting. And then the commission can make a better decision as far as if you're looking for additional information or placing possible conditions on.
Correct. So what I can do, and I'll talk to Mr. Murphy tomorrow, is I will tell him that we need to get an as-built plan as soon as we can, and hopefully we can have it for the next meeting. It won't be, it may not have everything on it that was approved, and then we can see exactly what's missing, and then we can put in, you know, all the missing pieces of the puzzle. We can get this thing taken care of. But unless you see it on paper and see what's done, we have no, we don't have any baseline. We don't know where everything, we know where everything is, but we haven't as built at any of it yet,
Right.
except the individual buildings when they went for the closings.
Right.
That we do have.
And I mean, I understand that, and Chuck, as you represent the engineering firm, you only provide what you are paid to do.
That
So
is correct. When we're contacted.
right. So the commission really does need to speak directly to the developer to get an idea of timing, and I think having or knowing that there is an upcoming closing at some point does put some pressure on the developer to move.
Exactly.
To get some of these long overdue improvements installed. I mean, clearly.
Correct. The only one that might be tough to do quickly is the DOT widening. I mean, I could see that taking a little bit more time than the internal infrastructure. DOT, sometimes it's a little tougher to get things lined up, but that is certainly on the horizon.
Right, and as far as improve, you know, once the drainage is done, utilities are run to the new building, you know, there really isn't a reason why the final coat of asphalt can't be put down and curbing and what needs to happen there.
No, absolutely, because one of the concerns was during construction, some of the machinery was going to damage the road, but you're correct. Right now, the building is in, and there's really not much heavy machinery that's going to be on the site.
Right.
So
Now we're looking at, yes, stabilize, you know, getting the rest of the infrastructure installed and stabilizing the site. Landscaping is another key. You know, I think some of these residents have been living there for several years.
Oh, yeah.
And now coming back, having to install drainage and tying in roof leaders, things like that. That's now cutting into the driveways. It's ripping up lawns that were stabilized. It's disruptive to the
Right.
residents.
We're gonna have to take a hard look and see what's done. I really don't. We haven't been to the site. Last week or this week was the first time I'd been there in many months. So we're just getting a handle on it, and I'll talk to the developer, and hopefully he'll allow us to continue our work so he can satisfy the commission. If he doesn't, then that's going to be another discussion.
Yeah, I got a quick question for you. You mentioned about before they get their certificate of zoning compliance.
Yes.
Is that done on each individual unit, or is that done
Yes.
once the complex is complete
No, it's per unit.
per unit?
Yes.
Okay.
So every time there's a closing, at this point, we've had 12 opportunities to apply some additional pressure. And at this point, I think that's a tool that's very useful from an enforcement standpoint.
So 12 units currently have certificates of zoning compliance?
Yes, 12 units are occupied. At least 12.
Yeah, and some actually have been bought and sold a couple once or twice, I believe. But there are COs on maybe 12 units right now.
It would be great to get everybody at the table, I think, Erin and Chuck, because also, we have Murphy's checklist here and, trying to work through that and against yours, Erin.
Sure.
Okay, so I could tell you the
Yes.
source of that. That it was a checklist, basically, Tony Bolduc from Stevens and Associates, when he met with Bob Murphy and myself and our zoning enforcement officer, John DeLaura. That was a result of all of the notes he took. There were some questions regarding changing phase two. Phase two at this point is irrelevant to our discussion. But those were basically the comments that I had raised based on my search, my research of the file and the site inspection that John and I had done. So some of the Lomar F and the flood things, those we've already resolved. And then I tried to clean that up into my memo. So
Okay, thanks.
that's just, that was the rough draft, basically recapping what we had discussed at our meeting.
Okay.
I think this is not a public hearing clearly, but there are some residents present at the meeting this evening from East River Farms. One particular, Craig Clausen, has his hand raised. Madam Chair, I don't know if you're willing to entertain any public
Yes, sure.
comments, but Craig, if you can unmute.
I'm unmuted. Commissioners, I thank you for the time tonight. I got to take a deep breath with this because this is not a business as usual matter. You have a partnership here that does not work. You need to know who you're dealing with. And you also should know that you have a builder who has an inactive building license right now. Does anyone know that?
That's not within the purview of this commission.
No, I know it's not in the purview, Aaron. I understand that, but it goes to the core of what is taking place here. And the fact that we last January 2021 got an opportunity to address the commission. And at that time, we were the ones here, the residents, to let the town of Madison know that the prior work permit had expired a year and change before that, and that the town didn't even know that it had expired. And then we asked for a limited work extension to February. It was granted to May, and here we are again. And we could talk about all the statutes of the state, and things could go to June of 23. But at the end of the day, your affordable is not being worked on in the interior. Nothing's going on there. The market one may or may not happen because work is at least 3 months away before that person could potentially even get in there. And I've met the buyer numerous times, and that person is extremely frustrated. This goes on at East River Farms on a regular basis. All we ever have here is stuff coming in and work being done, but it goes at a snail's pace. There is no desire on the builder's part to get this done quickly. And I'm going to say this for the record for all of you to understand. And you have a partnership problem here. And if you want to meet with me individually, and I'll tell you that as opposed to this, I will tell you things that you need to know that are real and they're facts. These are not things that we're making up. We know this through various sources. And so we are so frustrated in this development that we have something that was started in 2014, and now you're in 22 for 15 units through various good real estate markets, and there is no desire to get this done. There is none. And we are very concerned that you're going to get an extension to 23, and we're still going to be dealing with this as we were in January of 21. And when we asked for that shorter extension, and then the commission, after had it granted it, then got off the phone with us with the prior town planner, and then gave him another 4 or 5 months to be nice. And this is what's going on here, folks. So you need to get serious about this. You really need to get serious. This is not, we have a lot of violations, and we're having things. I don't know if you're all aware that the septic system for 14 and 15 was just put in yesterday. Is this infrastructure, how the town monitors a project, that infrastructure of this nature is done after the fact? I'm a real estate retired banker for 40 years. I know how these things go. I've lent money to numerous construction projects throughout the tri-state area. This is not the way business is done. And we are gravely concerned that the oversight here, and this is not directed at the current town planner. Aaron, you're new to this. We understand that, and you've done a nice job of trying to work with us. But this is a complete lack of oversight by the town for a project that should have been done years ago. And we as the residents suffer. We also have no ability at this juncture to have this turned over to the homeowners to run an HOA. We don't even run our own HOA. And if you look back in the legal documents, after 10 units, this was supposed to be a homeowner managed HOA. We're not even close to that, nor will we take it over because of the deficiencies within the development. We also have grave concerns that our monies are being used in a fiduciary responsibility. I'm going to go on the record of telling you that. So you have major issues here. This is not business as usual. So please, please take this seriously. You need to get Mr. Murphy and Mr. Altari in front of you. The mere fact that they did not show up tonight and the poor engineer who really has not been contacted in quite a while has to represent that tells you also everything you need to know.
Okay, thank you, Mr. Clausen.
Any other questions by the commission?
I think we can request that it be on our agenda for the June 2nd meeting.
Excellent. Staff will reach out directly also to the developer and
Yeah,
see if
I'll contact him tomorrow also and tell him the gravity of the situation and that he needs to be at the next meeting.
Excellent.
I'll do my best.
Thank
Aaron?
you, Chuck. Yes.
Can you get us the minutes for the meeting where the last extension was granted? Do you have those? I'm just curious what the, I don't. think
Yes,
I don't think
I can email those to you. There's not much of a discussion in the actual minutes.
Okay.
Or add it to the.
Yeah, the meeting may be on YouTube as well if you wanted to listen to it, but I'll look. I think it was January of 2021. I had it.
Okay, thank you.
Sure. I'll look that up ahead of time. Maybe just a motion to table this.
Yeah, I was wondering, should we make a motion to table it to our
Sure.
June 2nd, 2022 meeting? Could I have a second? Peter, thank you. Any discussion? All in favor? Until the next meeting.
Okay. Thank you
Great.
for your time.
Thanks,
Thank you,
Chuck.
Chuck, for coming.
Okay. Take care. Yep.
So moving on to approval of minutes from previous meetings, I'll turn it over to our secretary, Elliot Hitchcock.
Thank you. Two sets of minutes. The first one is from our April 22nd meeting. Members present were Snow, Hitchcock, McDowell, Hay, and Ruse. I will entertain a motion.
Actually, I had a couple of comments, Elliot, about those minutes. One was that the summary of the 2211 Wildwood Avenue motion. I think it just said that Peter Roos voted. And I wasn't sure if that was the right language or if it should be Peter Roos made the motion to vote as we voted. It seemed to be missing some, unless maybe I just don't know that that's how it can be written. I don't have them in front of me, but.
We can note that in that. So if
Yeah, to check
we'll
the
just
language.
check that language to see if it's a motion. We can go back to the vote and see what it was.
Yeah, because we seconded it, we voted on it. So I think Peter made the motion. I don't think he actually voted it.
Yeah, I think it was a motion, not voted, because at the bottom of it, it then has the vote count in favor.
Exactly. Thank you. And then also there's just a typo for Mr. Lulaj. His last name is spelled incorrectly.
Okay.
If we could correct that too, that'd be great. That's all.
Sure.
Otherwise, They look great.
With that, any motion to approve?
I move to approve with those changes. Thanks.
Carol, seconded.
I'll second.
Dr. Hay, all in favor? Aye. Opposed? None. They're approved. The next set of meeting minutes is from our meeting on May 2nd. Members present were Snow, Hitchcock, McDowell, Hay, Ruse, Mathers, and Bodenson. And looking for a motion on that one.
Motion to approve.
Peter,
I'll second again.
Dr. Hay, second. Any changes or discussions? Unmute.
You just mentioned it was the May 2nd meeting minutes, I think. It's
Oh,
the
May 5th, I'm sorry.
May 5th meeting minutes.
Sorry about that.
Okay, just semantics, but for the record.
May 5th, 2022. I was looking at all the twos in the 2022. So we got a motion in a second. All in favor? Aye. Opposed? None. That's all I have.
Great, thank you. Okay, on to remarks. Erin, did we want to talk once more about quotas and the, looking ahead to the June 16th meeting when we'll be down in numbers again? Were you able to?
So I think, and Ron's not here, but it's my understanding that we're going to, well, this is John and Peter's last meeting, unfortunately.
Fortunately.
Unless you're interested in reconsidering.
Not after tonight's meeting.
And I believe that Giselle, that's a very important weekend for you. So you won't be here on the June 16th, and Carol as well, right?
Right.
So I just trying to get a poll here of if we'll have 3 members. 3 would be a quorum, since our new total number membership would be 5. So we would need 3 members. I know Elliot. So if you could sooner than later, let staff know if you're available for that meeting. I can have Maria send an email out just to kind of poll everybody for the 16th, but I didn't want to get into a situation where we have a hearing continued or something when we know we won't be able to have a quorum. So hopefully this won't come up too often, and hopefully we may get 1 or 2 additional new members, but we don't know. So I think we just keep in mind and communicate when you know ahead of time that you have a conflict.
Thank you.
Erin, what if there is, I mean, as one of the likely only 3 members on the June 16th meeting, what if one of us got sick or there was some reason, some sort of emergency reason we couldn't make it? What would happen to those applications if there were only 2 of us who were there?
Well, so the meeting would have to be canceled because you can't open the meeting unless you have and handle any business unless you have a quorum. So it would, I mean, it's emergencies come up, so it's unfortunate, but it happens, and we would then pick up at the next meeting, basically.
Okay.
Did you have?
Aaron, I guess I have one other thing, just following up on that. I know we've been doing public hearings on both meetings every single month. I mean, with the shortage of commissioners that we have now being down to 5 and a little less leeway, would it make sense to go to only do public hearings once a month rather than twice a month?
Possibly. Yeah, I mean, we could definitely keep that in mind. We still need to have enough for a quorum. We still need 3 just to do any business. But the good news is that we're not getting a lot of receipts right now. I mean, we have a knock on wood, a little bit of a lull. And so aside from what you already have on this agenda, I have no new receipts that would require a public hearing. So it's a little bit of a, yeah, I think, and we can do that. I I don't have much flexibility with the Wall Street application because we're really pushing it out at this point from when it was received. But others, yeah, we have 65 days to hold a public hearing, so we might have to start getting strategic on when we hold them. That's a good idea, Elliot. So yes, I'll keep that in mind as we're getting new applications. Thank you for the suggestion.
And hopefully Noreen was correct with her email today to everybody, and that they start getting some, replacements.
So there have been, the first select woman did put out in her weekly blast last week, just a spotlight on planning and zoning. Excuse me. I did actually get an email from somebody interested in looking for the application process. Beyond that, I can't tell you that we don't have anybody in the works as far as getting appointed at this point. But I do check in with the selectman's office on a regular basis to see if we have somebody. And I thank you all for your dedication here until we do get a little more flexibility.
Erin, did you want to talk about the short-term rental?
Sure. I had two items, just wanted to recap. The affordable housing plan will have a public hearing next Monday, the 23rd at 6 o'clock with the Board of Selectmen. That's a hybrid meeting. And it will be the same presentation that you received at your May 5th meeting and allow for a public comment period. We're hopeful that the planning and zoning, the Board of Selectmen then move to adopt that plan later that evening at their regular meeting. So that's a good success, hopeful success. And thanks specifically to Peter, who served on that committee and was an asset to that group. The Board of Selectmen also have on their agenda for discussion some short-term rental concerns from neighbors in the Middle Beach and water area, the coastal neighborhoods down on the shore. So they're exploring the possibilities of creating some type of regulation, still looking to determine if there's a need for that, and have asked me to explore different flavors of regulating, a real light touch, a medium touch, and then a real in-depth ordinance type regulation. So this is in response to the initial complaints that were received by the land use office. And then while John Guskowski was here as interim planner, I know he brought that up before the commission, and you had recommended to the Board of Selectmen that likely regulation should be handled via ordinance as opposed to a zoning regulation. So that's where we are. No language has been proposed at this point, aside from an outright ban of any rentals less than 30 days. And that's the suggestion of some of these neighborhood groups. And it was a written request with 140 or so signatures on that application. So if you're interested in following along on this short-term rental discussion, I'm happy to follow up with you either offline or and share my initial presentation with you. I did just a brief slideshow for the board to kind of introduce the subject. So I'm happy to pass that along to you as well. And I think this will probably get started again with another follow-up in June with the board.
Okay, great.
And then my only other sorry, I know we're really ticking into the night here, for two items on the agenda. Virtual meetings, I think the last conversations that we had from the commission was to remain virtual for now. Here in Town Hall, we're trying to explore better sound and accessibility if we were going to move to a hybrid down the road. But for the interim, we do have the ability to maintain as virtual through December. So if you just wanted to kind of set things at that, you know, to remain virtual for the rest of the year, we're agreeable to that. And should we move forward with any more meetings about POCD, things like that, where we might need an in-person meeting, we can always address that at that time. But if the commission's agreeable, we'll just go ahead and update our calendar to remain virtual. That seemed to be preferable. And as I mentioned, I did say that's last, but I've been busy. The Plan of Conservation and Development RFQ will be going out tomorrow. That's the request for qualifications for a consultant to get on board. So we will be accepting bid proposals until the middle of June, and then meeting a small group, some representatives from the commission as well as staff to meet and open those proposals and perhaps do some interviews for a consultant where we can hopefully award a contract in July so that we can get moving for the next year and a half on our POCD update. So if anybody has any interest in sitting in that process, please let me know. That's it. Now I'm really done. Sorry.
I have one more thing, and that is just to thank John Mathers and Peter Roos one more time. This is our last evening together, and you will be hugely missed. So best wishes for your next big projects.
Thank you.
Can't wait to hear what else you're going to do.
Hey, Aaron, I had a question for you. So the POCD, will you be, I think I've asked this already, but is it just going to be the commission, or is it going to also be, you know, lay people off the street, so to speak?
We will be, the way that the 2013 was done, there was a working group with various stakeholders from the community involved. Representatives from various boards and commissions, neighborhood groups, things like that, other committees, as well as the commission. So it is our goal, while we don't necessarily have a structure of how we're going to move forward, that some of that we're waiting for a consultant to come. I did indicate in the proposal that, or the request for bids, that we would be engaging in a working group. So yeah, I think that's important to get as much, make this as, so what I'm looking for, as accessible as possible to the town and all our residents.
Thank you.
So, and I'll share a copy of I'll email out the bid package so that you can see it.
Okay, on that note, could I have a motion to adjourn?
I will do that one last time.
Oh, you can do it. Fighting for it.
All in favor?
All right, thank you. Thank you
Bye,
all.
Tron, and Peter, we'll miss you.
Take care, all.
Be well, don't be strangers.
I'm having great concert series this summer every Thursday night, so come on down every other Thursday.
Take care, all.
John.
Bye, everyone.
Bye-bye.